Hi, Parul. Very good morning. How are you?
Good morning, sir. I'm very well. How are you?
I'm doing good. So,
Yes.
Parul, please introduce yourself to us.
Sir, I completed my BA LLB honors in the year 2015, and thereafter I started practicing law in Delhi NCR. So meanwhile, in the year 2017, I also started pursuing my LLM in intellectual property rights. I completed the same in the year 2019. While I was pursuing my LLM, I got an offer letter from the Copyright Office, New Delhi, for the post of examiner of copyrights. So I joined that job. I worked there for around 8 months. Then I left my job and started preparing for judicial services.
Okay. So, Parul, you have done your graduation from which college?
So I've done my graduation from Ideal Institute of Management and Technology. It is affiliated with Guru Gobind Singh Indraprastha University.
Okay. And your LLM?
Sir, from the same university, but my college was there in Dwarka, New Delhi.
Okay. Okay. So, you completed your graduation in the year 2018,
15, sir.
2015. Okay. Fair
Yes,
enough. So, why did it took you so long to find judiciary as your targeted field?
yes, sir. So it is not a case that it was never in my mind. I always wanted to be a judicial officer, but sir, I am a first generation lawyer in the house. So nobody in my family had ever gone to courts or have ever, seen the courtroom environment. So that was my plan that I'm going to go to the courts for some time so that I can take a practical experience of what actually happens in the court, what actually a judge does, what is the role of a lawyer. And after getting myself versed with all these procedures, I'll officially give myself a chance to appear for these exams.
Okay. So, was appearing or was going for LLM your primary target, or did you found it to be part and parcel of doing LLB?
So it was a part and parcel of doing LLB only.
Okay.
I had always thought that I would pursue my LLM also, and maybe sometime my PhD also, but that was not in the near future. But I thought that I will be pursuing my PhD also.
Oh, okay. So, do you think we will be in the judiciary domain? Will we be allowing you to pursue your PhD in law?
Sir, I think I will have to check the rules and regulations for that. If that
Okay.
is allowed, that is legal, then I would want to go for that also.
Okay. So, although it has been long time, but what was the topic of your dissertation in LLM?
Yes, sir. So the topic of my dissertation was the critical analysis of the provisions of fair use, which is there in the Copyright Act, Section 52. That was the topic of dissertation.
And who exactly is an author under copyright?
Yes, sir. So the Copyright Act, first of all, defines author as a person, primarily is the person who has created the work. Whether it is he's the artist of a literary work or architecture or a sound recording or a cinematograph film, primarily a person who has created the same is termed to be an author. Otherwise, if he has licensed his rights or assigned his rights to some other person, then that person also becomes the author after the licensing and the assignment is done.
Okay, so you have used two terms over here, licensing and assigning. What is the difference
Yes.
between licensing and assignment?
Yes, sir. In the licensing deed, only some of the rights is assigned, and the author keeps little bit of rights with himself. He doesn't completely gives up his control over the work. He only assigns some. He only gives some of his rights to the other person. So while in the in the case of assignment, he actually loses his control over the work and completely assigns his right to the others.
Okay, okay. So primarily that is the difference between the two. What is the duration of copyright in our country?
Yes, sir. So it is the lifetime of the author plus 60 years after his death.
Is it 60 years or is it 50 years, Parul?
So 60 years.
Are you sure about it?
Yes, sir.
Okay. So Parul, moving further with your interview, what is your subject of inclination? What is your favorite subject?
So it is Specific Relief Act and Indian Evidence Act.
Specific Relief Act and Indian Evidence Act. So when we look at the Indian Evidence Act to begin with, to start this interview, what exactly do you think is the object of a cross-examination that is being done by the adverse party?
So first of all, as we know that the entire trial revolves around the appreciation and the evaluation of the evidences. So the primary object of cross-examination is to test the veracity of the witness.
Okay.
If he's telling the truth or not, whether the particulars he's telling has actually ever happened or not. So it is actually the other side, or the opposite side is actually testing the veracity of the witness to make it clear before the court that if he's telling the truth or if he's telling a lie. So that
Okay.
is the primary
That is the
purpose.
object of a cross-examination. Fair enough.
Yes.
And what is the relevancy of a rape victim's evidence when it is to be corroborated?
Yes, sir. So a rape victim's statement plays a very important role. In fact, it has been a dictum of the Supreme Court that a person can be convicted merely on the statement of a rape victim only. The court actually sees how consistent a rape victim has been as regarding his version is concerned. The court basically looks upon what was his version, or sorry, what was her version in the FIR, what was her version before the magistrate when the statement under Section 164 was recorded, and how well she has withstood the rigors of cross examination and other questions which has been asked by the court under Section 165 or the other provisions. If the victim has been consistent throughout, then even if there is no corroborating evidence on record, then the person can be convicted merely on the basis of the testimony which has been given by the victim.
Do you agree with this dictum of the Supreme Court that just on the sole basis of the evidence provided by the witness, the person should be convicted? Or as a judge, would you convict such a person solely on the basis of the evidence of or the testimony of the victim?
So may I take a few seconds to think
Yes,
about
please.
it? Sir, in my opinion, as far as the sexual offenses are concerned, because of the nature of the offenses, these offenses are normally not conducted in a public place. They are moreover conducted in a private place where it is very difficult to find an eyewitness to the incident. Sir, in such cases, a person has to rely a little bit upon the testimony of the victim, because she is the person who has undergone all the trauma. She's the better person. She herself is an eyewitness to an incident. Sir, in such cases, if the court will go on looking for some eyewitness to the incident, then the conviction rate will go very low, and it will be very difficult to serve justice to the victim. So in these cases, the guidelines do say that a court has to give importance to the statement of the victim, but at the same time, the court will be very cautious to see that it is not a fake case, and whatever story, whatever version is put up by the victim, that has some iota of truth into that. So the court will be cautious, but I think the importance should be given to the statement of the victim in such cases.
Okay. Is there any landmark judgment or a case law to support what you are saying?
I'm sorry, sir, I'm not able to recall a case name right now, but I think Mathura rape case, Mathura
Tukaram
judgment.
versus State of Maharashtra.
Yes, sir.
Okay.
I'm so sorry, sir. I'm not able to recall the exact name.
Not a problem. Not a problem. What are the fundamental presumptions which are provided under the Indian Evidence Act?
Sir, I'm just taking a few seconds to recall. So, Section 1112, the presumption of legitimacy,
Okay.
is one provision that I'm able to recall as of now. Sir, according to that, sir, in the cases where a person has to, where the legitimacy of the person has to be established, then if the person is born to a couple who is lawfully wedded, and the child was born during the continuance of marriage or within 280 days of the dissolution of the marriage, and the father is unable to prove that he had no access to the lady at any time when the child could have been begotten, the court raises the conclusive presumption that he's the legitimate child of the man.
Okay. Is
So,
there any exception to this general presumption?
yes, sir. Sir, if the man is able to prove that he had no access to the lady
Okay.
at the time when the child could have been begotten, then the court will not raise a conclusive proof because the man has already rebutted it.
Okay.
So in that case, that person can prove his legitimacy by proving other circumstantial evidences to that.
Okay. Okay. Any specific case law that supports your point over here?
So I can recall ND Tiwari versus State of UP case,
Okay.
wherein DNA test was conducted by the court
Yes.
To come at the conclusion that Mr. ND Tiwari is the father of the petitioner.
Okay. Okay. So is there a case that basically establishes that in cases of DNA sampling or the results of a DNA sampling can overpower the presumption which is laid down under section 112? Any specific case to that? ND Tiwari is one case. Any other specific case that you can recall?
I'm sorry, sir, I'm not able to recall the name as of now, but I know there is a plethora of jurisprudence on this point, but I'm sorry, I'm a little bad with case laws.
Not a problem. Any specific duration that you remember for presumption of survivorship and presumption of death as is provided under Indian Evidence Act? The duration for the two.
So may I take a guess to
Yes, please,
that?
please go ahead. Yes.
So is it 25 years?
No. You can give it another try if you wish to. We are talking about section 107 and 108 of Indian Evidence Act.
Yes, sir. Yes, sir. 7 years.
Okay. 7 years for survivorship or for death?
The survivorship.
Okay. And for death?
So I think it is 7 years only.
Okay. Are you sure about it?
So I'm only taking a guess, sir. I'm not sure about it.
Okay, not a problem. Coming to your second subject of interest, what does the term specific relief mean? What does this mean?
Yes, sir. So Specific Relief Act is basically a residuary law when the substantive law is not able to compensate or give relief to a complete extent. Then a person can come under the Specific Relief Act. So specific basically, as the word suggests, a particular relief. Something a person has asked, the court grants exactly the very same thing. So that is what basically specific relief is.
That is the specific relief. What are other reliefs apart from specific relief that can be provided as remedy in cases of breach of contract?
Yes, sir. So the court can grant damages under the Indian Contract Act, Section 73 and 74. Apart from that, sir, specific performance of the contract is one of the reliefs, sir.
Okay.
Injunction is also one of the reliefs.
Okay. And what are the types of injunctions as we see in the SRA?
Yes, sir. So there are two types of injunctions. First is permanent injunction and second is temporary injunction. Okay. And then there are subtypes to that. One is mandatory, one is prohibitive. So there are also subtypes to these injunctions.
Okay, so what is a mandatory injunction, Parul?
So mandatory injunction is basically, it is granted on the basis of the merits of the case, compelling a person to compelling a person to do a particular act or asking him to forbear from doing a particular act. So it is kind of putting an obligation of the person to positively do an act or positively forbearing from doing an act.
Okay. Good. So, Parul, do you know what is is today's headline of the newspaper?
Yes, sir.
What is it about?
So the demonetization notification, which was flouted by the central government on 8th November 2016, that has been upheld by the Honorable Apex Court in the ratio 4:1. So that was the headline.
Okay, and who's the dissenting judge?
Sir, Honorable Miss Justice B.V. Nagaratna is the dissenting judge in that case.
Okay. And what exactly is the name of the case?
I'm not aware of that, sir.
Not a problem at all. Coming to the current news or current scenario in the country, I'm pretty sure you're aware about the Mehroli murder case. In which the girl was cut into 35 pieces and then her body was disposed of.
Yes,
Are you
sir.
aware about the factum?
Yes, sir.
Yes. So, in opinion of various jurists, this falls in the category of rarest of the rare case. What is your opinion on deciding the criteria for death penalty in the country? And what is your approach? Let's say you are promoted and you become a judge for session court, you become a judge, and you are in a position to decide whether to send a particular person to imprisonment or to give him a death penalty. What will be your idea of deciding, or what will be your parameter of merits to judge whether I should be sending a person for death penalty or just sending him for life imprisonment or a fairly decent sentence?
So, sir, in such situations, a balance has to be struck between two things: whether a person can be effectively reformed or not, or whether the death penalty is going to have a deterrent effect on the society and set an example for the other people at large. So I would like to see the background of the person who is in front of me. I would want to see how educated he is. What are the mitigating circumstances? What are the aggravating circumstances under which the crime has been committed? What are the chances that if he's given a life imprisonment or he's given a lesser sentence, what are the chances that he can be reformed? What is his family background like? Is he the sole bread winner of the family? Is there aged parents behind? Are there children behind? I would also want to see, sir, what was the amount of criminality which was involved in the crime? Was he headstrong in producing the consequences? Was he aware of the consequences of his act? So I think I have to juggle between all these criteria to actually see that what is the punishment he actually deserves and whether it is a fit case to be sent to the Honorable High Court for confirmation or not.
Okay. So, good job, Parul. Good job. Well done.